Now, paragraph 6 describes some of the problems that you got to be concerned about if you file Chapter 13. And Chapter 13 is almost always relating to a foreclosure on a home or the threat of a foreclosure, where you're trying to save the home. And there have been many very successful ways of doing that. But paragraph number 7 really tells you what really counts. In either Chapter 7 or Chapter 13, you can sell or you can refinance your home at any time in your case. You just have to apply to the court for permission to do so, and then when you get that order, you can hand it to the people who are doing the sale or the refinancing, so they know they have permission to do that. Number 8 describes certain kinds of debts which are automatically non-dischargeable. They will not be wiped out automatically. Read through them at your leisure while you're filling out the paperwork. Now, number 9 describes other kinds of debts which will be wiped out unless they file a complaint and the judge rules in their favor. These are very remote cases. As I said before, I've not had one of these kind of adversary complaints to follow up on for 7 or 8 years now. Now, number 10 tells us the fairly obvious. Bankruptcy is only for the brave. It takes courage to file bankruptcy. Weak people will not. Even if it's dumb not to do so, they simply will not file bankruptcy. It takes courage also to give up a home that is underwater. Weak people will not. They will not even consider any alternatives, and they're usually stuck with these homes afterwards. But if you want to save your home, there's always Chapter 13. Give that a thought. Number 11, you must be honest and use your moral compass. This is not the time to lie, hide, or offload assets, max out your credit cards. You must be very truthful. Use bankruptcy to get out of debt, not to go to jail. B, take a look at 11B. Fraud against the court is not protected by the attorney-client privilege. No one should be so dumb to try. I will not permit my clients to get themselves in trouble and fib, fudge, or lie. C, be careful and be complete. Many creditors and their attorneys are great asset investigators. If you are sloppy, they will yell perjury. And so then is the question, are you lying or were you very, very sloppy? And I've seen some appalling cases where I thought they were just sloppy. The judges nailed them for it. Just be honest and be complete is what is required. And beware of the X factor. Ex-spouses, ex-partners, ex-friends, ex-neighbors can make great witnesses and may have financial information from the past. So be very careful. Ask yourself this question. What would these X-factor people say if they saw the information you provide to me and I provide to the court? Quit using your credit cards. If you use your credit cards after seeing a bankruptcy lawyer or getting the advice that you're getting now, you're committing fraud. Don't do it. Aggrieved creditors can, and on occasion do, rare occasions, file complaints objecting to discharging of their debt, the debts that are owed to them. If you have done something bad, full disclosure. Remember I said full disclosure, always over-disclose. Now, at this time, over-disclosure will allow me to give you proper advice and take corrective action. Your discharge can be denied if you destroy or conceal property, destroy, conceal, or falsify records, make a false oath, fail to explain the recent loss of assets, or financial information. No one should think that they can do it and get away with it. They can't. They shouldn't even try to do that. The point is, I'm amazed when I hear people who are not bankruptcy lawyers say how crooked my clients are or obviously have to be. The truth is, it's not true. It is a falsehood. These people are overwhelmingly honest and truthful, especially when they're told what to do and how to do it, and this is what I'm doing here. Read through number 12. There's some other information that you should have, and number 13 down, something about me, but there's more on the video on my qualifications. You can see that there. Now, this is page 6 of 8 pages, and we only have a few more to go here. These are real estate possibilities. If you have real estate that's you have some problems with, you should read through this one here. If you're buying or own any real estate, you may have one or more of these types of liens. The consensual lien is, for example, when you give a mortgage, you consent to them, you borrow the money, you consent to the mortgage on the property that you're going to pay them. Likewise with homeowners association fees and costs. Then the statutory liens, when the IRS puts a tax lien on you, or you owe real estate taxes, that's statutory, or a mechanical lien where you contract for people to do work, they put a lien on your home, that's a statutory lien. And then there's judgment liens when someone has sued you, gets a judgment, records it against property that you own. Take a look at paragraph 2. Consensual liens such as mortgages, home equity loans, homeowners' dues, you just pay them on a monthly basis. If you file bankruptcy, you want to keep your home, you got to keep paying those. Statutory liens cannot be wiped out, but they can be paid over 3 to a 5-year payment plan under Chapter 13. And judgment liens can be stripped off in Chapter 7 or Chapter 13 if they apply to your home. Therefore, they can be taken off. The bankruptcy law does not encourage people to go out very quickly, get judgments, slap them on people's homes, and expect to be protected. We can just avoid them, as they call it. We file a motion, we avoid their lien, and you keep on going on your way. Read the rest through here about possibilities of cramming down, stripping off the kinds of mortgages, and then there's mediation, which has become a big thing in the Orlando division. Our chief bankruptcy judge and a couple of the lawyers in the community have come up with this idea of going to mediation. The court orders it, and the creditors have gone along with it quite well. Apparently it serves their interests. So that's page 6. Page 7 here is a notice required by the Bankruptcy Code. The Congress says each debtor must be notified of these things, so read that when you have a chance, and then sign at the bottom there like you did all 4 of these last items here. And the last one now is page 8, the contract that we're required to provide. And if you look at this first one, the paragraph 1, hiring attorney. You do not have to hire me, but if you do, the terms and conditions set forth herein shall apply. If you find this contract to be unfair and unreasonable, see another attorney. Why not? Why would you want to come back if you thought this was unfair and unreasonable? And this goes in great detail to explain the kinds of services. We try to cover all of the remote possibilities, the basic stuff we all already know about. But read through this. It's perhaps boring, but it's also entertaining too, and you'll be fully informed. And that's what you have. 8 pages. The first 4, I give you information, you give me information that I need to see and evaluate, because this is the kind of information that I will have to give to the bankruptcy court. The other 4 pages, you read and sign them. And don't worry, when you bring these back, I'm going to make copies of it for you. As a matter of fact, most often what I do is I make copies in yellow paper from my file. I give these white papers back to my client. Somehow they feel a lot better when they get the original documents. I feel better giving it in that way too. That's the end of how to fill out the thing under Bankruptcy for Fun and Profit. Thank you very much for your attention. I appreciate it.